Hello, this is Forrest. I'm making a video today. I'm going to post this. This is really to go to anyone, but in particular some of our clients. I want to kind of go over a couple of things involving two areas and equaling the same outcome. And that is a tenant leaving the rental property. There's two ways tenants leave rental property, as you know, and that is a design to move out, an end of a lease, or they've paid a lease out and they're buying a house, something like that. And then, of course, there's the what I like to call the kicking and screaming method, which is typically the eviction method. I'm going to cover the regular move out first, and then we'll get on to the eviction. And it's going to take a few minutes, so bear with me, and unless you're just not interested, and then just skip it, go to something else. Okay, so if their lease is coming up and they decide they're not going to renew, obviously they have to give us a 30-day notice of non-renewal. We're usually reaching out to them 60 days in advance and ask them if they're going to renew. But let's say they don't get back to us within 30 days. And the scenario that I'm going to play out here is going to be the by the book move out for the tenant. And that would be if we've talked to them, they've talked to us within 30 days. They say no, we're gonna move out. We're gonna terminate the lease. We don't need to be living there anymore. We're not gonna renew. In that case, a lot of times the investor, the homeowner, let's say, has and I've run up against this many times with many of the homeowners. They have incorrect view of what happens to the security deposit. So if someone's coming to the end of the lease and they decide not to renew, or they're going to terminate the lease early and they've got a buyout structure, you still have to work with that security deposit. The security deposit, by law, is required to be held in escrow. You can't spend it, you can't look at it, you can't think about it, you can't even breathe on it at all until you make a claim on it. Now, if somebody moves out and they leave the place in good order, it's what they call broom clean, which is, everything's gone, they've swept up. In our leases, it does require them to have the carpet professionally cleaned when they move out. So let's just say, again, for scenario's sake, that they've had the carpets professionally cleaned. A lot of times when you look at this, they're called turns. Somebody's moved out, the place has to be made ready, as they're referred to sometimes, for the next potential tenant. The state of Florida, and I'm sure it's like this in many other states out there, the state of Florida has benchmarks, things that you can keep the security deposit for. When somebody is a plan to move out and they're going to go and they leave, you can't take the security deposit for the turn. I know a lot of people out there think that if you got to go in and do this and do that you can make a claim against security deposit. You cannot. The state of Florida says that there's normal wear and tear for somebody that's going to live in a place, that they're going to have, you're collecting money along the way for your rent, and you better be storing some away, because when they leave, the state's going to recognize that no one's going to live there and it's going to be untouched looking when they go. So in a turn, you could have to go in, and let's say there's smudge marks and maybe a scuff here or there. And a real good one is like holes, like where they little pinholes where they put up pictures and stuff. And you may have to paint the entire inside of the apartment or the house. The entire interior might have to be repainted. And this does happen sometimes, and I've told clients this before. When you buy a place, I would make sure they paint the inside white. The reason for that, if you have it some color inside, that color has to be matched. And I know there's different shades of white, but pretty much if they stick to a white, you can get it pretty quickly. But nevertheless, you might have to paint the inside. Now, if you paint an entire inside, depending on the square footage, you could be talking $1,000, $1,200 in labor plus paint. You might end up with $1,400-$1,500 painting a decent size, home or townhome or something, just to paint the interior. And you're thinking to yourself, well, that's a lot of money to paint the interior of our house. I mean, that's obviously not a lot of money. It costs that much to do, but that you'd have to absorb without claiming the security deposit. Now, you'd be right. It is a lot, but the state looks at that as, if you're going to have a rental unit, it's normal wear and tear. You normally have to paint when somebody moves out. They consider that normal wear and tear. You can't go after that. Now, cleaning. Let's say, and of course in the lease it tells the people, you got to leave it room clean and clean it. And again, you can say anything you want to in a lease. In a lease, you can require them to repaint the interior, and they're not going to do it, and they don't have to do it, because as soon as you try to file a claim against the lease and they hire an attorney and they take you to court, you're going to, not only are you going to have to give them the value of claimed back, but you're going to have to pay their attorney's fees and everything else. We had that happen recently. I'd say recently in this last year. And I advised the client against claiming the security deposit because it was all normal wear and tear. And in fact, the place didn't look bad at all. It just needed a paint job and some of the stuff, but they wanted to claim it. And they did. And sure enough, that tenant, they don't have to have an attorney. In this case, this homeowner got lucky because all this person did was go down and file it, basically file it in small claims court to reclaim the security deposit, which was good, because then the owner only had to pay back the amount that was claimed, and then the owner had to pay for the court cost to handle the mediation process, which was, I don't know, I think it was like $200 and something. I don't remember exactly the amount was, but nevertheless, the idea here is that if somebody moves out and it's not like a hole in the wall, and actually, I have to tell you, I've actually seen a case where there was a hole in the wall made by a doorknob, and we weren't the management group on that. A friend of ours was the management group on that property, and they filed a claim to have the drywall fixed and then the paint work done, and I think it was a few $100 to get that fixed or whatever, and they filed a claim against the security deposit, and you know what? They had to give it back. And then in that case, the other side did hire an attorney. So they had to give that back. And I mean, just for a few $100, they ended up paying like $800 for the attorney's fee for the tenant. It was crazy. But the judge in the case said, you know what? A doorknob hole would be wear and tear. Now I guess if somebody punched their fist through there or kicked a hole in the wall, that's going to be completely different. But the judge is the judge. The judge can say anything. The judge can say anything's normal wear and tear, and then all you can do is fight your way out of it. So the long and the short of that story is that when you have a tenant in a place, you need to, as you're collecting your rent, you need to squirrel away a little bit, knowing that when that turn happens, that you're going to have to pay for it, if it's like that. Now, timeline for all that. So when a tenant moves out, you basically have 10 days in which to make a claim against their security deposit. Now, of course, if they're moving out and you've had an agreed move out because they're not paying rent or something, have some back rent, obviously you can go against that and collect your money. But that does bring up an interesting fact. Let's say that you have a tenant that has, for whatever reason, they put up a double security deposit. Let's set their rent at $2,000. So they've handed you $4,000. And in their last month that they were there, they called you and said, I just can't do it. My lease is coming to the end. I'm not going to be able to make this rent this month. I'm sorry, I just can't do it. So what do you do? So what do you do in that case? Well, here's what can happen. If they and they'll stay, because there's no use in filing an eviction. Their lease ends in 30 days. You will not get that done within 30 days, and you'll incur a bunch of money. So what will happen is that when they go to move out and they leave the place decent to where it's only normal wear and tear, you're only going to be able to claim the rent that they owe you out of that security deposit. The other half of that security deposit, you're going to have to give them back. Even though they didn't pay that month's rent and lived there basically rent-free until the end, they're going to get that other half back. That's right. Now, of course, if they only have the 1 month security deposit for 1 month amount, you're going to make a claim and get that back. So I guess the moral to the story is, when somebody's going to, under normal circumstances, they're coming to the maturity of their lease or they've bought their way out of the lease, that security deposit can only be claimed under certain circumstances. It can only be claimed, under these rules of engagement, let's just call them. Now that we're past that point, so now you understand that when somebody puts up a security deposit, say the rent's $2,000, they put up a $2,000 security deposit. Then you can't take that just because when they did move under normal circumstances, the place had to be painted or had to be cleaned, or something like that. You can't take it for that. That's normal wear and tear. The courts are going to eat you alive with that kind of stuff. Now that that's out of the way, let's talk about something else on that. And as far as now, we're still in the normal move-out mode. So you have 10 days to make a claim. If you don't make the claim in 10 days, you have to give them a check. Now you mail them a check, you get a mailing address, and you mail them a check for the security deposit. Now, here's what happens. In most cases, we are holding the security deposit in most cases. But there are investor owners out there, or just regular owners out there, homeowners out there with rental properties, and they want to hold on to their security deposit, which they can do. They're allowed to do that. But understand that if the tenant moves out and we send you an email saying, hey, the tenant's moved out, the clock's ticking, we've checked it out, and we always shoot videos, so here's the video, shows you it's just normal wear and tear, the turn's going to be X amount of dollars or whatever, which then that homeowner would have to pay for that. We have to get that security deposit returned to us as soon as we can to distribute back to the tenant. If we don't get that, and the tenant says, hey, I didn't get my security deposit, then let's say they go and they take it to the court, we're not the ones that's going to be in trouble because we've reported you that we need it. If you hold on to that security deposit and for any reason you don't have it, or you don't turn it back over to us to be turned back to the tenant in time within that 10 days, you can actually incur some fees. I mean, you can actually, if they take you to court or file something or go tell somebody, you could get fined and fees and all sorts of things. The state is not like that when an owner keeps the security deposit, or even the management company keeps the security deposit. They are not down with that. You got to make sure, if you're notified, that you definitely get that money back to us ASAP so we can get that check out to them. And the law actually says that they have to receive it within 10 days if you're not making a claim. They have to receive it. So either the claim or the money. And so you're mailing it, you got to give that a day or two depending on where they moved. They may have moved across the country. So you have to take that in account. Days count. Fines are by the day. Fines are not by the month, they're by the day. If you're 1 day late giving it back past that 10 days, you could wind up with a fine. Now, most times you wouldn't be, but you can wind up with some problems. And because of that, we're very strict on our rules about owners holding on to security deposit. We're very strict on that. Now, again, if you're an owner and you're turning the security deposit back for that reason, then there's a turn cost and cleaning cost, or which would be in the turn cost, which then we're going to reach out and say, hey, we need a participation by the owner. We need you to send us some money. We'll tell you how much it is because we'll have a company go in and they'll tell us what it's going to cost, and we'll relay that to you. But all that kind of stuff is strictly enforced because obviously time is money, and we don't want to fool around with that stuff because it can get some legalities in there. So I hope I've covered the normal move out and you get a sense of making claims against security deposit. Now, let me say one more thing on the claim. Let's say in a scenario that there was something wrong and there is a claim that needs to be made on that. You have to send them, within that 10-day window, you have to send them, and we do it by certified mail, which you're not really required to do, but we do. We have to send them something that says, okay, this is what you did. We typically email them as well, and we email them a video link showing what was wrong. This is what you did. This is what goes beyond the scope of wear and tear, and this is what it's going to cost to fix that. Now that cost can be whatever it is. If it is a cost that is fairly high, and they say to you, hey, we want to come back and paint that, or hey, we can come back and fix that, or hey, the law's going to side with them. They're going to give them the opportunity within a short amount of time. They're going to give them the opportunity to come back and make the repairs or whatever it is. especially if it's something like the lease requires a professional carpet cleaning. Let's say that they left the place really in great shape, but they didn't get the carpet cleaned, and that will have to be done. But we don't really like turning properties unless the carpets get cleaned, because of, you get all kind of, you can get allergens in there, and who knows what else can happen. So you're better off having it cleaned. Even if it looks clean, it's probably not. So that really needs to be done. So let's say they move out and they don't do that. You can make a claim against that, but you have to, again, within that 10-day window, and again, figure for mailing time, within that 10-day window, you have to inform them of why you're going to keep whatever it is, $200, $300, $400, whatever it's going to cost to get those carpets cleaned, or whatever else it is. And then, of course, they could have the opportunity, if they say, oh, I forgot, I'll get the carpet cleaner right over there, within a reasonable amount of time, you're probably going to have to let them do that. You don't necessarily have to let them do that, but if you make a claim and you say, well, it was 4 days was too long for me, I'm going to go ahead and take the money and I'll keep it out of the claim, out of the return. Now, of course, once you've told them that you need the carpet cleaned and they say, I want to come back and have it cleaned, there is a reasonable amount of time there. So if they say okay and they drag their feet a little bit, then you're pretty much going to be able to get the carpet cleaned, and you're going to be able to, to stand on that legally pretty well. But again, this is all stuff you have to know. And that's what our job is, to make sure that you know this stuff. That's why I'm putting this video out there, because I want you to explain this. I want you to understand exactly what happens when somebody has a plan to move out.